Action. Oh, let me turn the volume off this game I was playing. Where's the mute? What up, y'all? Ooh, my bad.
That's weird.
Out of character. We're doing computer stuff today, sir. Gotta have the
I'm excited. It's gonna be fun. Harassment by computer is
Here's
very interesting
glasses.
statute.
Yeah, boy.
You gotta go, okay? Okay.
Buy my baby number 2.
Goodbye.
Well,
Bye, Uncle Baby Larry. They love you. Or say love you. Say love you, you goober. All right, go to mom, okay? Okay. Go to mom. I know she's over there. Go to mom.
No.
Yes. Go to Allie. Go on. I love you.
Bye, Daddy.
Bye. You heard her straight up tell me no?
Yeah.
No. Yeah, that's fine. Put it back.
No.
Don't smash your finger. Just put your stuff away. And then help her get out. Just put it back. Hi. You gonna go?
Why my wrist look so small? Maybe because I got a watch on.
Maybe. Go on. Love you.
Come on, Yay.
What's it? Bye, baby. Babe, make sure she doesn't smash her finger, sweetheart. So make sure she doesn't. And no one comes back to help. This is ridiculous. Go on, baby. I got you. Go on, mama. Go to mama and close the door.
Bye, Dad.
Bye, baby. I got it. Watch your toes. See you later. All right. You ready? Are we good? We going?
Yeah, we're right. This comment's just for you.
How you doing, God body? I'm excited. I think it's gonna be a fun one. I think everyone's gonna enjoy this one. I wholeheartedly do. This is crazy.
Yeah, that's why.
As I was reading it, I thought to myself, "Oh, this could have burned everyone in the early 2000s when Xbox chats were dangerous."
Oh, during the Call of Duty late night, playing Call of Duty all night long.
Bro, boy, it was crazy.
There was some good times talking shit back in the day.
You want to hear a crazy story? So recently I was playing Space Marine 2. And I was playing, and there's this guy who said, "Hey, everyone, can you guess what my Space Marine chapter is?" And he dropped the N word and just dropped it with a hard R. And I was like, "Oh, come on, man!" He just kept dropping it again and again and again, kept calling everyone one, and I muted him. And I'm like, "Man, I hope we lose this game. I really don't like this guy." And we smoked him. We won. And he wouldn't leave, so I had to play another 3 games with him, and he kept just cussing up a storm, so I'd keep muting him, but we'd keep winning. So I befriended him.
I'd have been like, drop your address, bro. You befriended him.
I'm joking, no, but I'm not going to lie. I didn't want to kick him because we kept winning, so I would have to mute him after he dropped another couple N-words. And
drop your address, bro. I got you. All you got to do is drop that address, and I'm going to handle it.
You ready?
I've been ready.
All right. Well, first thing I want to say is the same thing that I always say, Warlord. Say again?
I said, you see my bow tie, it means business.
That's very unique. But before I go any further, I'm going to say the same thing that I always say to you, Warlord. I do truly appreciate this opportunity. You don't have to do this. I am very grateful that you're willing to let me, get my little legalese on. And yes, Godbody, people are so brave online, it makes no sense. But I'm going to go over the same thing that I always do when it comes to something like this. First things first, everyone. Welcome to, Rules and Guidelines. It's a place where we talk about the rules and then talk about how sometimes they're more like guidelines, right? Now, I say the same thing I say in the beginning of every episode. First things first, I go from generals to particulars. I am only talking about Virginia. I am an attorney that is licensed to practice law in the state of Virginia. I do not talk about other states. If you're interested or inclined to look at how this situation may apply to your particular state, I say firmly reach out to an attorney in your area that's licensed to practice law in that particular state. I'm not trying to in any way allude to the idea that I'm licensed to practice anywhere but Virginia. I got a job, I got a license. I don't want to lose either. Also, most importantly, I am licensed only to practice law in Virginia and emphasize only Virginia. I love criminal law, so if you guys ask me questions about any other field of law, I may not be able to help you, but I'll do my best. Now, most importantly, this is for educational purposes only. I am in no way trying to establish attorney-client privilege with anyone here. I got 3 kids and a wife. I am not trying to lose my job, so please, please, please remember this is for educational purposes only between myself and my best friend. So now I am going to get into this one. I think you guys are going to truly enjoy it. What's up?
I was singing. I said, me and my best friend.
So, harassment by computer. The code for it is 18.2-152.7:1. It's that weird. It's ridiculously long. Now, before we get into it, Warlord, tell me, misdemeanor or felony? It's that weird. It's ridiculous.
I thought it
Think about this one. Think about this one.
Death threats, misdemeanor. Hey, ladies. Hey, Sonny. Hey, Erica. Misdemeanor.
Yes, it is. Misdemeanor 1. Way to be, brother. All right. So, for harassment by computer, there's 3 elements. First one is there needed to have been an intent to coerce, intimidate, or harass another individual, right? Now, what is this? We talked about this, right? Mens rea. Circumstantial evidence is needed to establish this. So they're going to consider everything in order to determine what your true intent was as it pertains to your conduct that was done. Element 2, you had to have used a computer or a computer network. We're going to go deep into that because you'd be surprised on what is and isn't considered a computer or computer network. And lastly, and this is a 3-pronged one. It could be one of these 3. Hey, sweetheart, how are you, baby? It could be one of these 3. You needed to have A, communicated an obscene, vulgar, profane, lewd, or lascivious. Oh my gosh, I can't read. Lascivious, thank you. Or indecent language. Or B, make any suggestion or proposal of an obscene nature. C, threaten any illegal or immoral act. Now, as a just FYI, out of those 3, one of those is going to be super easy to hit. The other 2 are going to be a lot harder. We're going to go over some important aspects as it pertains to this statute, specifically venue and why it may be harder to bring out this charge for certain areas where it may occur. We're going to talk about the statute of limitations, and we're going to talk about other relevant statutes as it pertains to this particular charge. Now, again, there's 3 elements. It's not super complicated. It's not overly complex. The only thing that you're going to realize is it's besides the actual intent aspect, all of the entire focus or analysis when it comes to harassment by computer is really built upon one element. And we're going to go over which one they spend a lot of time on. Now, what do you think to harass is defined as, brother? Do you think that they have like a special definition for it?
For harassment? Continuous annoyance. Bothering.
That's fair. Now, there's a case that in my mind is super petty, but I think it kind of finally for the first time lets everyone have like a common sense approach on it. What they say is a person with ordinary intelligence should know what intent to harass means.
So
exactly. This is Perkins v. Commonwealth, 1991. They just says, hey, look, it shouldn't be, and I guess one of the common notes is that the determination made in Perkins was intended so that no one can argue that this statute's too vague. It's pretty much they're using a common sense interpretation and approach in order for people to say, what does it mean to to have the intent to harass? What is harass? But to take it a step further, there's a case that was resolved very recently. I want to say in 2021, Nelson, which says harass means to vex, trouble, annoy continually, just as you said, or chronically. So they derived that from, you guessed it, Webster's. So now we've talked about this in the past when it comes to the actual interpretation of statute. Some people are textualists, some people are purposivists, meaning some people look at the words straight up of what the statute says. Some people try to, in some way, derive the purpose from the statute by taking into consideration circumstances that were occurring around the actual creation, anything that was relevantly happening. I know whoever watching better drop a like in this. Hey, that's true, D Hill, and I do appreciate it. And first things first, I want to say this. Everyone, again, I do appreciate this. This doesn't have to be a continued thing. If you guys didn't like this, or if you guys aren't a fan of it, let Warlord know. I love the law, and I'm realizing that this is something I truly enjoy. I love teaching. I love helping people understand the laws that apply to their everyday life. It's the reason why I love crim law. Crim law is awesome because no matter what happens, this is always going to apply. We may not all be billionaires. We may not all be landowners. We may not all be trying to merge companies. We may not all whatever. Everyone can be harassed via computer. It's literally anybody. So now I mentioned it earlier, right? And what I mentioned was intent, right? Warlord is considered and kind of gauged based on circumstantial evidence. They take into account everything. And I think the biggest thing, Nelson v. Commonwealth talks about the comments that were made. So this gentleman said ultimately that he was calling 911 and he kept calling 911 because he thought that he had some type of heart palpitation, heart issue, right? Now, he would call, but for some reason there would be a disconnect. And he kept calling and calling. And ultimately, he got online with Sergeant Greg. And Sergeant Greg was the individual who initially brought out the charge. However, the circumstances surrounding the calls demonstrated that he wasn't actually attempting to intimidate, to harass anyone. And the facts that they said ultimately were that he only stayed on the line for the least amount of time possible. The purpose was expressed for making the call. And once that was expressed, the call was ended immediately. So, and I think the biggest thing that I want to say about Nelson, which is kind of one of the points that I really wanted to emphasize, is I know in prior instances, assault and battery, I believe, is one of the charges that we addressed earlier. Intent was something that could also be derived from just statements made, statements alone. Me and you were in a disagreement. I say, I want to fight you, right? Then actions can be conveyed, or actions can be interpreted through the lens of, well, he made the declaration, he wanted to fight him. So when he does this, it's due to, you could apply intent to act. However, for this statute in particular, your stated intent isn't enough. They have to take into account circumstances surrounding it. So I believe, and that was also from Nelson v. Commonwealth, which in my opinion, I thought was very, very important. Now, remember, it's not just the intent to harass. It could be one of the three, right? Intent to harass, intent to intimidate, or intent to coerce, right? Now, I got this one case, Rives v. Commonwealth, RIVES v. Commonwealth. This happened in 2012. I'm going to say there's a little bit of vulgarity, so I'm going to bleep that out as best as I can. Now, in this case, they had a transcript that the Commonwealth brought that showed that, again, Rives only made 10 phone calls to this victim. It was between 5 p.m. to like 2 a.m. Over the span of like a couple hours, I want to say, right? He left a couple voicemails. Now, these voicemails are pretty straightforward as it concerns what the intention was, but I'm still going to read them. Hey, B word, You want to wonder why you don't have any friends? B word. I'm going to F word you in the worst effing way. You understand me? That was voicemail 1. Now, that is clearly what? Those are threats, right?
You should
Clear
just read.
threats.
Well, ask them though. Ask them. Well, whatever. That's an easy one. Don't ask them that. But yeah. Yes, clearly threats. Yep.
Now, this next one is kind of the one where we'll see. Hope you have a good time with this S word, and what's going to happen is not going to be pretty. The portion in particular that people had the biggest gripe with was that last bit.
So
And what's going to happen is not going to be pretty. That was interpreted to be intimidating. Warlord, what do you think?
Well, ask them. I mean, to me, he's implying he's going in full force, no Vaseline. What do y'all think, chat? Are you guys listening? This is like a kid show, one of them like Dora the Explorer ones, where we wait like 5 seconds. Then we all go, it's B. But yeah,
That's correct. Well, see, and I think the difference between the initial voicemail as it pertains to threats and this one concerning intimidation is, remember, you have to take them all in context, right? So 4 voicemails were made or were left. All 4 of these voicemails shared a similar tone. Now, that's actually what made me delete social media and never started up again till this YouTube. Godbody, I'm going to be honest with you. Once I go through this, yeah, I'm going to be honest with you, Godbody. After I go through this, I'm going to be surprised if people still use social media as much as they do. Because I promise you, misdemeanor 1. All right, max punishment for misdemeanor 1, Warlord, what is it?
Why don't you ever ask them?
Okay.
I remember this one because you asked me 3 times.
Misdemeanor 1, max punishment. How many months incarcerated?
Answer it. 60 seconds. What's the max punishment for misdemeanor 1?
Misdemeanor 1.
Got one answer.
D Hill says 6 months. Boo, 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 boo. Da, da, da. So, max amount of time you could get for a misdemeanor 1 is 12 months, but D Hill is technically right because misdemeanor time is half, meaning if you got 12 months for a charge, you have to do 6 months in order to satisfy. So technically, D Hill, you are right. Now, I think that last voicemail on Rise v. Commonwealth is kind of clearly intimidating, but I think it's clear only when you take into account the other 3 text messages that were left. Now, they actually make a statement as it pertains to it. They conclude that the question whether language used in telephonic communications is obscene is immaterial in cases involving threats to commit illegal or immoral acts where the threat is made with the intent to coerce, intimidate, or harass another person. I'm going to be honest with you. Yeah, JP, it's up to 12 months or below. Now, that honestly, folks, I think that is going to be the biggest thing about this particular charge that people don't understand. When it comes to, again, 2 of the 3 elements as it pertains to the last one, which is it's right here, the communication, the nature of the communication. Obscene is concerning 2 of the 3, but that last one is I'm telling you, it's as I was reading it, I'm like, oh, that's a catch-all all day long. And we're going to go into why it is a catch-all, but heads up, we're going to go into it and you're going to realize like honestly, after I read this, you should not have social media. I promise you, you should not. Now, we did intent to harass, right? Intent to intimidate or intent to coerce. This next one, right? In this particular case, we got Hudgens v. Commonwealth. you have multiple statements that this bucko makes. First one he says is he calls in a Miss Numergit and told her that he's going to come over and burn her house down. One. Now, Miss Numergit believed that Hudgens was drunk on something, so she kind of disregarded it. He called her a couple weeks later and said he wanted to be with her, and that if he couldn't be with her, he's going to blow her head off. Boom. That's two. Yes, that is two. Now, it wasn't until this last actual comment that was made that Miss Numergate that was actually worried. Now, he called again, identified himself, and told her that if he doesn't start seeing her, he's going to, cut her neck. I don't know what words are gonna like buzz us or, but that he threatened her with that. Now, he called again later, and he said, and I think this was the part that totally emphasizes the intent to coerce. He knew that Miss Numergit loved her son more than anything in the world. And he said that they're going to be together. Otherwise, he would take out the little B word as well. Now, they emphasize the last statement in Hudgens v. Commonwealth because coercion requires an awareness of certain aspects of the complaining witness's situation, and you to try to manipulate or capitalize on that weakness. As a primary aspect of coercion that needs to be kind of illuminated or demonstrated. The fact that he was aware of her bond or her closeness to her son and then made that statement was kind of like telltale signs of his true intent to coerce, right? To try to get that date. So it obviously, I mean, I don't want to make light of these situations because these are very, very, very troubling facts. You don't say you could do institution. That's funny. This one, all right. Wits v. Commonwealth is another instance of, I'm going to read them, Warlord, and I want you or the group chat to tell me what you really think, because this one, the ones I gave you earlier, those were a little like, they're just painfully obvious. This one, right. I don't know. And even if you look at it, even if you take into consideration the context that's established, I could push back on this. Now, listen, it's Wits v. Commonwealth. This happened in 95. Mr. Wits called March 12, 1993 to inquire as to his job status because he hasn't received his termination letter. Mr. Christian, his boss, testified that Mr. Wits stated, "I have some fireworks for you," and he was going to bring all three down. That's all he says. "I have some fireworks for you, and I'm going to bring all three down." Mr. Wits testified that he spoke with Mr. Christian, and upon being informed of his termination, stated, "You, Wayne Lett, and Mr. Haney, all of you, you're all going to fall." Mr. Wits had once grieved an early termination by the city and was planning to grieve this one as well. He testified that the context in which the above statement was made was that he was going to get an attorney and fight his termination, and that the statement was not intended as a bodily threat injury against the named individuals. Now, Warlord, what do you think? The statements, and I'm going to restate them. What he said was, "I have some fireworks for you. I'm going to bring you all down. You, Wayne Lett, Mr. Haney, all of you, you're all going to fall."
Yeah, I think that's one of those things where, somebody wasn't threatening you in that way, unless they were doing hand motions and gestures. But then you would have to have cameras or whatever to record that like if you like, I got some fireworks for you, all y'all gonna go down, homie.
See, like a ninja moment. No, but you're right, Warlord, and I think that's the biggest thing about this. I think I need more. For me, I don't think there's you're all gonna fall. I mean, your company's gonna fall. Yeah, your financial situation's gonna fall. Like, you know what I mean? Like, I have some fireworks for you. I'm gonna bring all three down. Bring all three down. I mean, again, he has, and I think this is the part where I don't know which v. Commonwealth's peculiar. He has grieved an early termination by the city in the past, and he was planning on grieving this one. For me, that's you want to bring all three down. You obviously had issues or grievances with the city. You tried to fight that. Now you're trying to fight that. I just don't. I don't know, man. I don't know. Now, obviously, for them, the biggest thing, Warlord, and actually, before I say it out loud, what statement do you think is probably the most important or the most damning as it concerns what was said by Mr. Witts? Do you think it's the I have some fireworks for you? I'm going to bring all three down. You, Wayne, let Mr. Haney, all of you are going to fall. Which one of those three statements is the worst, in your opinion?
I mean, I want you to ask them, but they're going to take too long to answer. I would say the fireworks part, because if I was a Karen or a Carl, I'd be like, oh, he's threatening, he's going to shoot me.
Well, honestly, that's exactly what the court said, Warlord. The court said that I have some fireworks for you, followed by a statement that I'm going to bring all three of you down, made under the circumstances show that he was intending to intimidate the three the business owners. So yeah, man. So yeah, remember, intent to harass, intent to coerce, intent to intimidate. Those are the three. That has to be observable. Again, that's the mens rea aspect of this statute, right? You need to have intentionality. There needs to be the mental state showing that you meant to do what you did. Now, remember, context is big for that. But it's one of those three. If we have one of those three, we're good as it pertains to element one. Now, I'm going to give a fact pattern at the end of this to see where you're at. But again, element two, this one's pretty self-explanatory, man. This is the use of a computer network. Now, Warlord, I'm going to read these two definitions, and then we're going to try to just think of stuff that isn't a computer. Because I'm going to be honest, it's going to be harder than you think it is. A computer means a device that accepts information in digital or similar form and manipulates it for a result based on a sequence of instructions. Such term does not include simple calculators, automated typewriters, fax machines, or any other specialized computing devices that are pre-programmed to perform a narrow range of functions with minimal end user or operator intervention and are dedicated to a specific task. That is one.
I could easily send a threat through a fax machine, though.
They said fax machines don't count. They said fax machines don't count. But this is where the rubber meets the road. Computer network means two or more computers connected by a network, which means I think you're right. I think maybe a computer by itself, but two fax machines is enough. I would argue that's a computer. Am I like I would argue that, or a computer network, excuse me. Now, this is where it gets interesting. A person uses a computer or computer network when he attempts to cause or causes a computer or computer network to perform computer operations. Warlord, what is a computer operation?
Anything a computer does.
Exactly, bro. Like, that's the thing. Like, as I was reading this, I'm like, what? Like, why are you? A computer operation for a particular computer may also be any function for which that computer was generally designed to complete.
Right.
Like, what? Why are we? Again, brother. Arithmetic, logical, monitoring, storage, retrieval functions, and any combination thereof, and includes but is not limited to communication with, storage data of, or retrieval of data from any device or human hand manipulation of electronic or magnetic impulses. Again, that is the thing about this statute that's so ridiculous. It's almost like they tried to be forward thinking, which I respect that. I wholeheartedly do, because this is ridiculously complicated. And the last thing you want is to be ridiculed or mocked for writing a statute that, went obsolete the moment that they created PS5s or whatever. But for me, this one's just too... I think they try to do too much. However, Warlord, iPhone a computer?
Wait. Say, I thought you were saying you bought a
I said
computer.
Warlord. Is an iPhone a computer?
Yeah, phones are supercomputers.
Exactly. Laptops are regular computers. Okay, and this is for all of us gamers. Warlord, Xbox or PS5 a computer?
Yes.
Um, is Facebook a computer operation?
No. Stuff that happens in Facebook is a computer operation, like sending messages. Facebook
So
itself
then
is
would Facebook be a network?
it's a part of a network. Yes,
Yep.
it's essentially a code. But yes,
Yep. So, so we know computers, we know laptops are going to be covered, cell phones are going to be covered. I mean, gaming systems are going to be covered. Again, man, we know fax machines are going to be covered. Like we know. So I guess the next thing that we need to figure out are what needs to be communicated, right?
like
Now,
the coercion or the whatever the other one was again.
remember, intent to coerce, harass, or intimidate.
Oh,
So
right.
intention, right? Intention. Also, I see that the chat's going off. Oh, they're talking about Sigana. What's her? Oh, the victim in this case was a D-boy. I went through his window and to his bed, his stash, and called the cops and told them I stole. Dang. Yeah, I'm not gonna lie. Sigana. Yeah, that's interesting. That's interesting. Okay. Now, if I were Sigana's attorney, if he is a real D boy, like she says, I'm inclined to say he'd have a criminal history. And if he has a criminal history, I'm hoping or looking for any charge that is related to crimes of moral turpitude. Why am I looking for crimes of moral turpitude? Because in the state of Virginia, if you're found guilty of crimes of moral turpitude, lying, cheating, stealing, the like, you testifying is inherently untrustworthy and you are impeachable by definition, which means you are viewed as less credible. So, Sigana, hypothetically speaking, whoever was your attorney, I hope that they did their research to figure out if that bucko had a criminal history, which if he's a D boy, I'm almost guaranteeing he does. So I would definitely hope that they picked at that because
That's a
if
show
not,
right there.
say
That's a
again?
show, Andre. I think one of the times it'd be good to get into can your history or criminal history affect your current case or whatever. Like that.
Well, yeah. I mean, if I'm being honest with you, I just explained how it can. So one of the biggest things in criminal law in general is impeachability, whether or not you can be impeached. And some individuals are just impeached simply because of their criminal history. And I just said it: crimes of moral turpitude in the state of Virginia result in your testimony not being viewed as credible. So that'd be very interesting to dig into. But before I get any further, so there's two aspects, two of the three when it comes to the third element. You need to communicate obscene language, or you need to make any suggestion or proposal of an obscene nature. Now, Warlord, what do you think they're alluding to?
You gotta physically
Obscene.
type, huh?
Obscene.
What?
What do you think that they're trying to like convey
Yeah.
when it comes to
You,
obscene?
you gotta physically type or send something that's like criminalizing, I guess, rude.
So
Or
obscene is a
right.
very interesting. They give a definition, but once I explain it, you're gonna look at me and be like, "How? Like it's yeah." So check it out.
Okay.
The word obscene means when considered as a whole has a dominant theme or purpose to appeal to a prurient interest in sex, that is a shameful or morbid interest in nudity, sexual content, sexual excitement, excretory functions or products thereof, or sadomasochistic abuse. Oh my gosh. Thank you. Which goes substantially beyond customary limits of candor in description or representation of such matters, and which, taken as a whole, does not have serious literary, artistic, political, or scientific value. Warlord. How is that obscene? Like, how hard is that? Like, to try to nail down what obscene is? Like, so they have a breakdown of ultimately what it boils down to. They broke it down. That which, considered as a whole, has a dominant theme or purpose that appeals to the prurient interest in sex. So I think vulgar, right? Think vulgar. It's shameful or morbid. It's beyond custom limits of candor, and there's no serious literary, artistic, political, or scientific value. Now, anyone who if I'm pretty sure people would realize that similarly mirrors some of the protection provided in the First Amendment. And in my mind, I think that alone shows that this is a damn hard one to prove. It's ridiculously hard. Now, I'm gonna pause real quick. When they arrested me, I told them that I took product, not cash, thinking they'd be on my side. They said, "You still burglarized someone's house?" Yes. Yeah. So hypothetically, Sigana, yeah, confessing that you broke into the individual's house, didn't take cash for product means that's still a B&E. Godbody's right. You should have said nothing. That is the safest thing. However, be advised, if you did take product only nothing, more likely than not, that product would probably be a Schedule 1 or 2, which means that's a possession. Possession is Schedule 5, which who knows what a felony 5's limits are. Warlord, felony 5. What is the minimum and maximum that you could get for a felony 5?
I think, what was it, like 10 to 20 years? 10 to 25 years?
Felony 5.
Oh, felony 5 is lowest or lower. That's 5 to 10, right?
No, 1 to 10.
1 to 10.
Felony 6 is 1 to 5. But yeah, Sigana. I did 6 months for that dumb move. Yeah, 6 months for. So wait, Sigana, were you hit for possession or which? Wait, what were the charges? They must have null process. She only did 6 months, hypothetically. If she only did 6 months, she was in possession. I don't know what the air quote product was, hypothetically.
You didn't say nothing about possession, though. She just said she took product. I think she said burglary. I said she didn't.
Yeah, that must have been
bullet fall from.
So
she didn't say anything about possession. I think she just said burglary.
Okay, so back to this. Now they talk about obscene. He was known to. Interesting. So back to obscene. Barson v. Commonwealth. It gives us an example. Now they talk about what obscene is. The definition. Now. Barson is this individual. He emails his wife accusing her of infidelity, saying, air quote, she was having sex with anonymous strangers on Craigslist. She has a new hobby of soliciting sex on Craigslist. She's having a risky gutter sex life and vacuuming his baby to death and of being a coke whore, baby killing prostitute. Those were the statements that he made to her. Warlord, are those obscene statements?
I don't know. They're vulgar for sure, but I don't know if we can go with the obscene.
Yes, Warlord, you're right. They're not obscene.
Okay.
Ridiculous, because a coke
vacuuming my baby, like
vacuuming his baby to death. Yeah, this is wild. Okay, so Earhart v. Commonwealth talks about certain things. Although the words like whore and fuck are sexually explicit, Earhart's usage of the words was not erotic and did not have the purpose to appeal to a prurient interest in sex, but was used in a communication where he told the victim to leave his roommate alone. Now, in this one, let's apply that same rationale, our hearts, to Barson's. Barson, he was saying she was a coke HWORE baby killing prostitute. Now, was that appealing to a pruning interest in sex? I'm going to say no. He was just communicating his anger for her and her promiscuous lifestyle. So I would say that's not obscene.
I would agree.
Sigana, what state did those charges arise out of? Back to this. Now, he was my man at the time and he was cheating on me. Oh no, but the only thing he cared about was his money. So I tried to hit him in his pockets. Damn.
She's in New York.
Yep. She's in New York. That would be that would be a cool episode for her to come up and talk about it. LOL, he sent me to jail before that when I beat up the girl after he brought her to the house when he knew I was home. Yikes! New York. Yo, that's diabolical. How are you gonna bring so all right, before I go deeper into this obscene stuff, that is you got nerve, Warlord. You got nerve to bring home a feet, not you, Warlord, but like you gotta have nerve to bring home to bring home some, some side pieces when the main is at the house. That's crazy.
Right. Right.
That's never in my day. That's diabolical.
Crazy, bro.
So, Lofgren v. Commonwealth was another case that happened in 2009. So this gentleman called the victim, and he said to her, "I can't believe you effing see you next Tuesday. You are a effing B word. I hate you. I can't believe you're doing this. We had plans." Now, they took out the charge for that, but again, Warlord. And then he left her a voicemail calling her an effing see you next Tuesday, and saying that she effing sucks. Now, me and you have now learned. He introduced her to her. That is, she's got to be on one of these. I want to know her story. But again, Warlord, the comments made by this gentleman saying she's an effing B word, he hates her, he can't believe she did all this, whatever. Again, they don't appeal to the prurient interest in sex. Although they're very vulgar, I don't see them going beyond the customary limits of candor. And I do think that there is. I think that there is value. I wouldn't say it falls under a literary, scientific, or political. Maybe art. Maybe artistic. I don't know. What we do know for sure, Warlord, is what it's not. I would say it's not obscene. Clearly not obscene. Like clearly.
I was going to ask you, if she ever said stop, just once, if she ever messaged him stop, could that be considered harassment? If she ever messaged him stop, then he kept going? Or does it take more than once to say stop?
Well, I would say, honestly, that would be, I think that his intent to harass would be clear. I think that would be clear. I think that wouldn't be an issue. For us, the issue was the message that was conveyed obscene in nature. We already know that he used, we already know the other two elements are satisfied. It's clear based on the context that he was trying to harass her. He was that's clear. And I'm almost guaranteeing that it's a non-issue on whether or not a computer or computer network or a computer device was used. So it's just this obscene one. So now we know, right? We know obscene as it pertains to the first branch. It's communicating obscene language. That's ridiculously hard to like achieve. So I think that that's not the one, right? There's another one. Make any suggestion or proposal of an obscene nature. What are we thinking, y'all? I'm thinking, trying to, suggest somebody to do some naughty stuff, right? Now, this, huh?
I said a pee pick.
Yeah, something like that. I would presume, but I would say even that would be considered protected by its artistic value. Now, is it entirely prurient? Bro, hear me out. Hear me out. I would say this. There's a shame, or is it? It obviously would appeal to your prurient interest in sex, of course, if you're asking for that type of pick. Shameful or morbid interest, clearly. Substantially beyond customary limits of candor, clearly. And this is the thing: all of those three prongs have ands on it, which means they are conjunctive, meaning you need all three. If they were disjunctive, if they had an or, you just need one of the three. Now, these are all conjunctive, which means they have and, so you need all of them. The last one, taken as a whole, does not have serious literary, artistic, political, or scientific value. I would argue it's artistic. I would say, Your Honor, respectfully, my client is enamored with the human body. They have paintings displaying the body in its pure form, unclothed. And I would say that my client pursuing this particular pick of this particular area of the man's body was only trying to gauge its artistic appeal. Your response?
I don't know.
Is it not artistic?
No, it's not. But I guess it'll work in court.
The green one? Why are you gonna take that? Can't have nothing in this house. I was comfortable doing my thing, and Siri's like, nice pillow. Run that.
Right. Pretty sure
I like the way that pillow looks.
One in one hand and the belt in the other.
Yeah. I'm interested in this case he's talking about. Were these people in a relationship? Because dealing with a F-boy or girl will have you out here acting crazy. Yeah, they were in a relationship. Sigana. So, yeah, it's just, this is obscene. So what I really want to stress and convey to everyone is those two prongs on the third element, obscene, making a suggestion or proposal of an obscene nature, or just an obscene communication in and of itself, because of the standard, it's too hard to it's too hard to satisfy the element under that prong. However, Warlord, this is the easiest prong, and I'm telling you all, this is the reason why you wanted to watch this. Threaten an illegal or immoral act. This is why that prong, this is why that playing video games nowadays, or texting somebody nowadays, or Facebook, social media, this is why you should stop. Not because of the illegal part, the immoral part. Hear me out. The third disjunctive element, a communication that threatens an illegal or immoral act, does not require proof of obscenity. An illegal act violates the criminal code. An immoral act violates society's social code, reflecting its collective sense of moral propriety. Do you know what that means, Warlord?
I mean, I guess to put it in normal words, it sounds like it's saying it might not be illegal by law, but society does not accept that. So we can give you some type of charge for that.
Exactly. Now that we heard this part, and we're going to go into some cases with it, but man, oh man. All right. So now, Warlord, check it out. Now that we went over all three elements, right? Intent to harass, right? Intent to harass, intent to coerce, intent to intimidate. That's one. Intent. 2, communicate via computer network. Element 2. Element 3, either obscene communication, obscene suggestion or proposal. Again, I'm thinking, trying to suggest naughties, or illegal or immoral acts. Fact pattern. Me and you were playing video games. Me and you were playing Space Marine 2. A guy who's on the mic, who's playing for the other team's talking trash. And me and you talk trash back. He says, you guys are garbage. You guys are da-da-da-da-da. And we say the typical gamer stuff. F your mother does this and that to me and my friend. I'm pretty sure your dad likes to watch.
Yep.
Think about it. Gamers would say that to each other. They would say diabolical things to each other. Now, Warlord, let's say he says, stop saying that. That's mean. And me and you keep going. Me and him, we're playing PvP. I drop him and I'm talking trash. Oh, you drop to you're laying on your back like your mom. All this other stuff, right? All this other stuff. Warlord, did I intend to harass, intimidate, or coerce him? Clearly intend to harass. Clearly, right? Clear as day. Now, was I using a computer or computer network? Yes, I was.
Mike, yep.
PS5 would totally constitute a computer. and playing over, communicating with two computer network, easy, right? Now, element 3, it wasn't obscene, right? Even if we were going the obscene communication, I mean, we said things that are gross and all that other stuff, but would it be obscene? I would argue it wouldn't be. I would argue it'd be protected by political value or even artistic value, those easy ones, right? Now, was it a legal proposal or suggestion? I would say no. Why? It's not like we're asking his mom to do these crazy stuff. No, it wouldn't be that. Would it be a threat of an illegal or immoral act? Yup. All day long. It would be that
maybe.
all day long. Say again?
Immoral, maybe. I don't know about illegal.
And again, brother, remember, threatened and illegal or immoral. Remember, or, not and. Or means it's disjunctive. You need one of the two. If it was conjunctive and, you need both of them. But because it's disjunctive, it's or, you just need one. And now, think about as a prosecutor, if I read this, illegal or immoral, and immoral defined by Motor v. Commonwealth says it's just the act done violates society's social code reflecting its collective sense of moral propriety. Oh my gosh, I could play with that all day long. Would society approve making comments or statements pertaining to the sanctity of another's mother? No.
It depends on who you ask in society. If it was other gamers, you told them it was why we're gaming PvP, they're like, yeah, that's acceptable.
Now, exactly. You're right. And this reminds me of the old conversation we had with JP. Now, you're right. But do you think a judge is a gamer?
Some.
Do you think Commonwealth attorneys are gamers?
This one is.
I'm a public defender. I'm criminal defense, not a prosecutor. But the point, right? The point is what? The point is, more likely than not, you're going to have people who are totally detached or have no connection or understanding as it pertains to the social dynamic involved in gaming, which means you can get hit with this easy. Literally, it takes nothing. All right, everyone in the chat, how often does it happen that arguments or conversations had on social media get a little more rude or aggressive or confrontational? It happens all the time.
Every day, like this whole group in the chat, some way or another has seen or is involved in some online confrontations. Oh, sorry, you asked them, my bad.
No. That's a good point. See, Ghana's going in. Sheesh, her current husband is too shook to try anything. Good Lord. But no, I think that's a good point, man. Like, but I want to say, like, hypothetically, right? All the time. I think that's the point, right? You talked about how there's people who currently now they're on social media or on YouTube or whatever. And again, all it takes is one crazy comment that could be viewed as immoral. All it takes is one crazy comment saying something to the effect of, when I find you, it's on site. What's on site? Are you suggesting that you're going to try to shoot at them? That's definitely illegal.
I'm going to shake your hand.
Remember, intent to intimidate, coerce, or harass, that's all circumstantial, which means they can look at the entire conversation, doctrine of completeness. They can look at all of it to try to get the total context and try to identify your mens rea, your intent. Which means what? Which means it takes nothing, man. Now, look, there's a case. Now, they bring up wits again, and they talk about the fireworks and how the fireworks, not even looking at it through any other lens, if you look at it through the immoral or illegal lens, it would totally be hit by it. So, it's, again, man, I would just suggest to everyone, you got to be careful. You got to be careful online. It takes nothing. Now, some of you may be asking, Professor Hamilton, you genius of a man, you demigod, you Olympic warlord. How do we protect ourselves from this type of charge? And I think the biggest thing, especially when it comes to stuff like social media or interactions that happen over, great distances, it's all about venue. Now, venue, for everyone who's like kind of like, the hell venue? What are you talking about? Venue is where it needs to be appropriately heard, right?
Mhm.
So again, venue, right? Location. So venue for prosecution of computer or other crimes. That statute 19.2-249.2. What that essentially says is, if you're going to try to for the purpose of a violation of harassment by computer, um, the act need to have occurred or been addressed in one of these ways. Now, where did the act actually occur, right? That's one. In which any act was performed in the furtherance of any course of conduct that violated any provision listed below. So where did it occur? Now, the
I do
owner
kind
has
of
a principal place of business in Virginia. What's up?
I do kind of got a question kind of pertaining to where
What's up?
things are. Is it different? Does it make a difference if some of those things is said on a more privately owned platform like YouTube, for instance? Because you know how like people like YouTube has different laws and stuff. They're protect them themselves is protected from me threatening you online because they're not a publisher or because you know the way that they set things up. So does that change anything? The type of social platform that it is on a computer, or is it no? The point is you threaten me or harassment by computer, basically.
Again, so based on what we read, I would argue ultimately it doesn't necessarily matter the platform. It doesn't matter if it's TikTok, Kick. I wouldn't argue that actually matters. What I would argue is the biggest issues concerning this particular charge are: do you have jurisdiction over the individual who did it? Did it happen in the Commonwealth of Virginia? Odds
Mm-hmm.
are the act isn't going to be obscene because we just discovered how hard it is to prove that. So,
Yeah.
lastly, was the communication made concerning anything that's illegal or immoral? That's going to be the big three things that are hard for you. The illegal or immoral seems actually pretty easy because of that immoral prong. It seems like anything could, you just got to make a reasonable argument. Well, I'm guessing a prosecutor would just have to make a reasonable argument that would suggest or demonstrate that the comments made would go against the, and I quote, violate society's social code reflecting its collective sense of moral propriety. That is crazy. That is that
So
easy.
if I threaten somebody in Australia, technically they don't have jurisdiction, but say the police is monitoring, I don't know, Twitter, and they see me say I can be charged, but would that person be able to bring up the person in Australia be able to bring up charges on me?
No, they lack PJ in Virginia. And
Okay.
PJ is personal jurisdiction. So
Okay.
we probably need to spend maybe a day one of these days going over what personal jurisdiction is. The long story short, before you actually bring out a charge against someone, you need to make sure that the place that you're bringing the charge out, you have personal jurisdiction in, right? If I am trying to sue you in, let's say, New Hampshire, I need to make sure that I have jurisdiction, like that one, they have jurisdiction over you in New Hampshire, but also that they have jurisdiction over me. Now, usually consent is the easiest way by bringing the charge. It give me that I'm consenting to them having jurisdiction over me. So that's not the hard one. It's usually the other party. So to bring up your fact, right, or bring up your scenario, you made a comment. You made threats to an individual in Australia. The acts occurred here. The actual, the effect occurred in Australia. He comes here to try to bring out the charges against you. I would argue you live here, so it's appropriate
Mhm.
venue. The computer's here, so it's appropriate venue. I would argue it's proper here if he brings it out here. Now,
Okay.
hypothetically, let's say you had a VPN, right? and they were not
Mhm.
able to confirm based on your, what's that fancy thing that you tell me about? Your
Oh
each
my,
computer
oh my.
has it. No, your each computer has it. It's like a it's unique to each
VPN.
computer. Huh?
Oh, the IP address.
IP address. If they weren't able to confirm by your IP address where you were at the time that these messages were made, will they ever have proper venue if you try to bring out a charge in Virginia? I would say no. Unless someone was willing to dime you out and say, I saw when he wrote it and he wrote it here, then maybe. But on that note, I'm going to stress, oh yeah, you would forfeit your computer. All monies or other income, including all proceeds earned but not yet received by a defendant from a third party result of a violation of this charge, would result in all computer equipment, all software, and all personal property used in connection with the violation to be forfeited to the Commonwealth. Just heads up.
So what kind of, so if I bring up a charge on somebody, they're going to take my computer from me until they're done with the investigation?
Ultimately, they can. So, like, I think a prime example is like unauthorized concealment of a firearm. Usually, they can request that they
Right.
keep that firearm for it to be destroyed. Now, again, I'll have to dig into it to see if that's required by statute. I think that's a policy like adopted by that particular office. But yeah, I want to say the one thing that I always kind of hammer whenever we do stuff like this. Always look it up. See how it works in your particular state. If you have questions, comments, concerns, please do not hesitate to reach out to a local attorney. If you want to ask myself or Warlord further questions or additional questions for the sake of clarity, by all means, you're welcome to. Again, I love doing this. I love the law. It's fun. It's crazy. The more I read it, the more I realize that it's so easy to break the law. I hate to say it that way, but it's true. Which means you got to be careful. I'm a firm believer that, the less you know, the more, at risk you are. So please,
Right.
look it up, figure it out for yourself, check it out just to figure out what you think. And again, I would say check it on this, what I just went over. Hey, what is he talking about? Is he even right? Let me Google harassment by computer. Is he just making it all up? Okay, well, I found the statute. What does this mean? Okay, I read the statute. It makes some sense. Let me figure out if there's any cases that are publicly accessible that I could read to try to figure out what's actually happening. Because again, I want to stress another thing to everyone. Like, this is fun. I know this is really just us talking to you. There's not a lot of interaction, and that's fine. But the big thing that makes this beneficial for everyone involved is by you pushing back. If something doesn't make sense, ask a question. If something doesn't even seem right, ask me to explain why. And I had a I had a client recently. Now, without going too deep into the information, I don't want to violate his attorney-client privilege, his or her. This individual had a bunch of charges, and he ultimately was given roughly 35 months in total of misdemeanor time, which everyone knows misdemeanor time is halved. So he got 36 months. So roughly he has to do at least 18. Now, this individual has been in since the beginning of the year, and that means he's almost been in for roughly, let's call it 9 months. We just resolved a felony recently, and he was given X amount of years to spend all but time served. Now, initially, because the prosecutors were trying to request a certain amount of time, we were both under the impression that he was only going to get those months, let's say hypothetically 3. Now, that's not what happened. That's not what was written down. He's confused, yelling at me, saying, "Why didn't you explain this? You gave me more time. You gave me more time here." And I'm saying, no, it was all suspended. They just took some of the time that you had. You're not going to be given more time. Now, I could have easily said, whatever, it's over, it's resolved. I'm not going to seek out an answer for this guy because we're done, right? I could have done that. But what did I do? No. I reached out to my legal assistant. I said, hey, we're going to figure this out. I'm going to call the records, the head of records at the local jail. Break down all his charges and how much time he got for all of them and when his release date is, right? Well, it turns out they suspended all the time except whatever he sat for. And I was under the impression he sat for more time for this particular charge, but he didn't sit for any. So,
Oh, wow.
yeah. Now, what that means to the average person is, well, if it said the sentence was suspended all but time served, it sounds like if he didn't do any time, then the entire sentence is suspended, right?
Right.
Now, the court or the local jail Googled a few things and turns out that they found a couple days that they could give to this felony. So, you know what? He actually sat an additional 4 or 5 days for this charge. We're going to put those 4 or 5 days towards that. We're going to suspend the rest of the sentence. So I explained it to him. I was like, hey, look, this is what happened. This is why it happened. You didn't get more time as a result of this felony getting resolved. They found time for you, but your release date is this. That isn't going to be changed. XYZ. I provided additional clarity. Why did I tell the story to you all? It's because if you don't seek out the answer yourself, if you don't just not only know the answer, but know why that answer is the answer, you're going to be left in the dark. So Google it. The statute is 18.2-152.7:1, or just simply Google Virginia Code harassment by computer. It's going to pop up. Now, read it. Tell me what you think. If it makes sense, hey, this is super simple. Andre, I think that you're wrong. I think that obscene is easy to satisfy. And then I'll say, hey, show me a case that shows obscene being, show me why. Easy, right? Or, hey, I agree with you. Obscene is ridiculously hard to prove. But you're right. Illegal or immoral acts is a little too loose, too free. Why? Well, show me why. I'll show you a case that is ridiculous. That satisfied the element. So, again, I apologize, everyone. I'm long-winded. But what I'm ultimately getting at is this is ridiculously important. It's important because the more you know, the safer you will be when you carry yourself accordingly, when you conduct yourself in society. If you know, again, actually, perfect example. Warlord, me and you are sitting in my driveway. We're sipping a little something. You know what I mean? Sipping a little something, a little splash of something. Cops drive by. Hey, gentlemen, what are you doing? Me and you say nothing. They get close to us. Is that alcohol in your cup? We say nothing. They come over, they smell the cup, they say, whoa, that's alcohol. And I look down to see that there's a half empty bottle near me and you. Is that drunk in public? Yeah.
Public? I mean,
Is that drunk in public? Us drinking in the driveway? Is that drunk in public?
I'm guessing you're going to say yes, but I would say no.
It is. Are you observable by anyone just willy-nilly walking down the street?
I guess. I mean, even though you're on your property, I guess so.
I would say this. I would say the typical Googler, look it up. But if you can be observed, it's like the plain view doctrine, right? Do cops need search warrants if what they're looking at or what they can see is something that's observable just by them walking by?
Right.
No, they don't need a search warrant for that. Plain view doctrine. So I say this is a way of saying, pick at it. Always go look. Always go try to figure it out for yourself, because the more you know, the more you can do. And that's all. I mean, again, knowledge is power. Whatever you want to say, whatever cliche you want to use, it's always important. You always want to know more, especially when it comes to something like this, man. Because it does not take much to get wrapped up in something crazy. It does not take much to accidentally, catch a case, right? So I will say the same thing that I always say at this point in time. Warlord, I appreciate you, man. I know you don't have to do this. I know you don't have to let me come up here and yap. Everyone who's watching, I appreciate it. I don't care if you're having side conversations. I don't care if you're chiming in periodically. I don't care if you're actively invested. I appreciate you being here.
Open
You do
yourself
not
on
have to be
oil.
here. So for that, I am truly grateful. Again, Warlord, I appreciate you, man. Everyone else, I appreciate you. Thankful for this. Yeah, if you have any questions, comments, let us know, man. All right, y'all.
Cool.
Y'all take care.
All right, y'all. I'm not gonna be long-winded. I will say thank you all for coming in. I need to run out, go take care of some stuff. Appreciate y'all. Y'all have a good evening. I agree with that, D Hill. Getting pissed off. You come to that door like, hey, I know who's coming through my door. But anyways, we'll have to ask Andre about that one. I gotta go run, GB. I gotta go run. Before what time is it? Before it gets too late. Yeah, I still got time. I gotta go. I got something that can entertain you. Yeah, for real, D Hill. They better not come jump through my door. I thought somebody was trying to break in and attack me and my daughter. You better announce yourself. You better do it loud enough for the whole house to hear. Thank you, Erica. I appreciate that. Jack from Mortal Kombat. That's what's up. I'll take that. Y'all gonna keep me here trying to read these. I'll give it till my soda's done. Oh. Night, Sonny. You be letting anybody in, Capri. You live in Wisconsin. You can have some protection. Better get that blicky. Keep that blick on you. Yeah, it's like when I'm at the crib by myself, anybody's welcome to come over here and get stupid. I've said it once, I'll say it again. Me and my dog, we be over here bored sometimes if I'm at home. Anyways, my soda's done. I'm getting out of here so I can run. Well, get you some sage and blicky, Capri. Yeah, definitely D Hill. Good night, Capri, Gloss, Sunny, Body, Mimi, D Hill, Erica. Anybody else I might have missed? Most of the Twitter. Nope, that's it. And whoever else is watching, bushes or not bushes, y'all have a good evening. Thank you, everybody.